Welcome to MyR Video. Today, we're going to discuss a very important topic under the Companies Act 2013, different kinds of issue of shares. Whether you're a commerce student, a budding entrepreneur, or just someone interested in corporate laws, this video will help you understand how companies issue shares and the types involved. So let's get started. Different kinds of issue of shares. Section 24 of Companies Act 2013. Share means a share in the share capital of company and includes stock. It represents the interest of a shareholder in the company measured for the purposes of liability and dividend. Types of shares. There are two types of shares under Companies Act 2013. Equity shares, all the share capital, which is not preference share capital. Preference shares, issued capital which carries a preferential right with respect to payment of dividend and repayment of capital. Let's now understand the difference between equity shareholders and preference shareholders in simple terms. Point number 1, voting rights. Equity shareholders have the right to vote on every resolution placed before the company. That means they have a say in all important decisions, like appointing directors or approving major policies. On the other hand, preference shareholders have limited voting rights. They can vote only on specific matters, such as if there is a proposal that directly affects the rights attached to their preference shares, in case the company is being wound up, and if there is a proposal for repayment or reduction of the equity or preference share capital. Point number 2, voting power on a poll. In case of a poll, equity shareholders' voting power is proportional to the number of equity shares they hold. So the more shares you hold, the more voting power you get. Similarly, preference shareholders also get voting power in proportion to their paid-up preference shares, but only in the situations where they are allowed to vote, like we just discussed. For more detailed information, visit the official website of VMK Professionals, www.vmkpros.com, and always review the latest amendments before execution, as laws keep changing frequently. Section 23 of Companies Act 2013. Section 23 says company may issue shares by way of public offer through prospectus, IPO and FPO. It is only for public companies. Private placement, right issue, bonus issue. Issue of shares by right issue, Section 62(1)(a) of Companies Act 2013. What do you get to know from term right issue? An invitation to the existing shareholders to purchase additional shares of the company in proportion to their paid-up capital at a discounted price, i.e. lower than the market price. In other words, a company having a share capital proposes to increase its subscribed capital by the issue of further shares. Such shares shall be offered to the existing holders of equity shares in proportion to the paid-up share capital on their shares at the time of further issue by sending a letter of offer. This is also called preemptive right of existing shareholders. Provisions of right issue under Section 62 are applicable to all types of companies. Why to do right issue? What are the reasons? Control of company remains in the hands of existing shareholders. Company can raise more debt as the debt-equity ratio reduces. Company is unable to borrow money from outsiders, but it has to meet its capital requirement. Procedure for right issue. Board meeting to be called for approving such issue. Company shall inform its shareholders regarding number of shares offered and limiting a time not being less than 15 days or such lesser number of days as prescribed under Rule 12A and not exceeding 30 days to decide. As per Rule 12A of Companies, Share Capital and Debentures, Rules 2014, the time period within which the offer shall be made for acceptance shall be not less than 7 days from date of offer. Offer letter and notice shall be sent to shareholders by registered post, speed post, electronic mode, courier having proof of delivery at least 3 days before issue opening. If the shareholder does not convey to company his acceptance for further issue of shares, he shall be deemed to decline the offer. Offer shall be open for at least 3 days after issue of offer. Offer shall remain open for minimum 15 days and maximum 30 days. However, in case of private companies, if 90% of members agree in writing electronically, lesser period can be specified. Option of renunciation can be given. Renunciation should not be restricted by the AOA. File MGT-14 with registrar within 30 days of passing a board resolution. The requirement to file MGT-14 exempt in case of private companies video notification dated 4/01/2017. For more details, refer the link https:/w.gov/bin/ebook/dms/get-document.docket-nz1 and docket notifications and type go open. Call the board meeting for allotment after file Form PS3 within 30 days from the date of allotment of securities. Company shall issue share certificates S1 along with making entries in the Register of Members MGT1. Unsubscribed shares, if any, can be disposed of by the board in any manner which is not disadvantageous to the company and its shareholder S. Note, for every issue, return of allotment in Form PS3 is to be filed with the ROC irrespective of whether the shares is allotted through private placement, employee stock option plan, right issue. For more detailed information, visit the official website of VMK Professionals, www.kpros.com, and always review the latest amendments before execution, as laws keep changing frequently. That's it for this video. We hope you learned something new about how companies issue different kinds of shares and the legal provisions behind them. If you found this helpful, don't forget to share your thoughts and experiences in the comments below. We'd love to hear from you. Also, make sure to like, share, and subscribe to our channel for more videos on company law, business, and compliance. Thanks for watching, and we'll see you in the next one.